To our Facebook Live broadcast. I'm Steve Altition, Director of Client Partnerships here at Pacific Cascade Legal. And today we have our limited license legal technician, Christy Carpenter, with us to talk about modifying a child support order. Hey, Christy, how are you doing today?
I am doing wonderfully. How are you, Steve?
I'm doing well. It's not raining. That's a good thing. So, Christy, before we start in on modifying child support orders, can you just briefly go over what a child support order actually is and encompasses?
Okay. A child support order sets forth a monthly payment that an obligor parent is to make. And that child support payment is meant to cover the necessities of life for the child. So shelter, food, and clothes, basics, whatever that child's portion of rent or mortgage, utilities, and then food and clothing. There are other expenses that a child support order can address that would be additional payments. And some of those expenses are medical, whether that's the premium or any out-of-pocket expenses like braces or copays, daycare, dependent care if a child is disabled and needs home care, education, which is not things like school supplies, because that's to be included as part of the basic child support payment. I'm talking extraordinary expenses like private school tuition, tutoring, driver's ed classes, college application fees, that kind of thing. Then we've got long distance transportation. So if the parents live a great distance from each other and the child needs to be transported back and forth, or one of the parents goes back and forth for visitation, then that can be included. And then the last is kind of encapsulates other expenses like summer camps, sports costs, extracurricular activities like music lessons, scouts, that kind of thing.
Got it. So, obvious question, but I love to answer the obvious question. What you can put in a child support order then is the only really things that you can modify a child support order about.
Correct.
It makes sense, but sometimes some of the straightforward stuff can be really tricky. And so let's get now to modifying then a child support order, and the basis for doing it. When can you do it even?
Okay. So there are three legal bases for a modification of child support. The first circumstance when you can modify at any time since entry of the prior order. And you can do that if there's been a substantial change of circumstances of a parent or a child. The most common, and which happened recently, is an involuntary under or unemployment situation. And that happened a lot during COVID because obviously people, mainly in the service industries, could no longer work. And so I did a lot of modifications based on that sort of substantial change. Other reasons could be incarceration of a parent who is obligated to pay, or release from incarceration, an injury of a paying parent that affects employment, that kind of thing. So the second circumstance when you can modify is if it's been 1 year since the prior order is entered and the order works what's called a severe economic hardship. So let's say suddenly the paying parent has huge medical bills due to a complication, and they have to pay those medical bills too. Now the court's going to weigh whether the paying the medical bills takes priority over paying child support. Probably not in this example. So severe economic hardship, and you have to prove that. The other criteria for modifying after 1 year is if you need to extend support for a child beyond age 18 who is still in high school. Now, most child support orders terminate the support payment when a child turns 18 or when they graduate from high school, whichever is later. But I have seen some orders terminate child support at 18. So sometimes a child turns 18, their senior year of high school, and you need to extend it. Also, if a child has to repeat their senior year, which again, I've had that happen during COVID because they just weren't able to keep up with the requirements to graduate. And so a child turns even 19 when they're a senior, and we need to extend that. It's also possible. The third criteria is after 2 years since the prior order was entered, you can modify if there's been a change in income of either parent, and that's probably the most common basis for modification.
Got it. On the anytime one, to use the term substantial change of circumstances, I'm assuming that means that the change has to be, for want of another word, a big change. I mean, if I, get a $2 raise, that may not be substantial. Maybe it would be, but it's something bigger than smaller, I'm assuming.
Right. For example, winning the lottery. If you have a parent who wins the lottery, obviously they can support the child more than they had. So that's major. And I kind of went over some of the other things too.
Right. So what can be modified?
So first thing that can be modified is changing who the payor is, and that would happen in the case if a child or children move from the primary residence of one parent to another. So you need to change who the paying parent is. The monthly payment can be modified, and it's important to know that the monthly payment can only be modified from the time that the petition is filed forward. Let's say a parent has been unemployed due to COVID for 1 year, and they file a petition. Well, the change that any court makes will be only from the date that the petition is filed. You can't go back and ask that the modification be retroactive for that year. You can modify the end date for support, and we just talked a little bit about that. If a child's still in high school, you can add a provision for post-secondary support, and that's very common. Normally, most of your child support orders they'll reserve that provision that a parent or parents pay for college for a child. And it's reserved because the information really is not known when a child is, for example, 2 years old. You don't know if a child's going to college, and you don't know what the parameters of that would be. So normally it's reserved. However, a lot of parents do go ahead and put in that they will pay. Typically, it's in agreed circumstances that they'll go ahead and pay for college for a child. So you can add that secondary support, post-secondary support provision. And when a court is considering whether to order the parents to pay a child's college tuition and other expenses, they will consider several factors. So the first is, what were the expectations of the parents while they were together? Did they talk about, sending their kids to college? Did they maybe put money into a 529 account? What is the parents' level of education? If both the parents have college educations, it's more likely that a court would order that for a child. What are the child's desires, aptitudes, and abilities? Obviously, if a child is getting straight A's and they kind of know what they want to do, like during their junior or senior year, they maybe have already applied for college. They've already taken their PSAT and done well. So the court will look at that. The type of post-secondary education, whether it's 4-year, 2-year, trade school, apprenticeship, and then even Running Start. If a child is in high school, I believe most of the fees for Running Start are covered, but you can request that the parents pay whatever fees are remaining for that. The standard of living of the parents. So the court will look at really whether they established that higher standard of living while they were together. And again, that kind of relates to expectation. And then the last criteria is the financial resources of the parents. A court probably is not going to order a parent who's making $20 an hour to pay for their child's college education. So as I kind of got into college college attendance needs to be imminent in order to modify that provision. So a parent, if they're planning to do that, needs to be prepared to file a child's grades, file acceptance letters, file, a lot of colleges put out what the average cost of attending is for a year, and they'll put out, tuition fees, books, room and board. And so you will have an estimation of what that will be. And so you'd want to file that if you wanted to modify that section of a child support order. If indeed a court does order that the parents will pay post-secondary education support, you can request that payment of the monthly support amount be extended during the months prior to the child starting. So if the child graduated in June, typically the monthly amount would end in June, but you can ask that it be paid in July and August if they start in September. And that's just a provision I like to include. You can also ask that the monthly support amount continue in addition to payment of the post-secondary education expense if a child is staying in the home while attending college, because obviously that parent is still going to have those expenses for a child. You cannot ask for post-secondary support beyond age 23, except in exceptional circumstances such as disability. And you can also ask that the court extend medical coverage to age 26 if it's warranted. So that's the big one. You can also add or change provisions for payment of the other expenses that I mentioned earlier, such as medical, daycare, long distance transportation, and activities. So if you had a bare bones child support order that didn't allow for any of those payments, then you could add them when you do a modification. And then the last item that you can change is who claims the tax exemptions for the children. So often when you enter a child support order initially, you may have several children. Obviously, as they age out, they're no longer claimable on taxes, and so you may want to make changes to that. And I guess that's it.
You mentioned early on that I believe you said the obligor or the obligee can ask to modify.
Either one, yeah.
When you get into this college stuff, and if one of them doesn't, I mean, can the kid ask to modify the support?
No, because the child is not a party to the action. It's
Got it. So you also mentioned, and I thought it was really important, I just wanted to touch on this because it goes to my next question, it's the filing process. How do you get started? How important is it to get a hold of someone like you as soon as one of these things happen? Because I believe you said it goes just back to the date of filing, right?
Correct. Yes. So it's very important to not wait.
Yeah. So the filing, that the first thing you do. I mean, how do you get started?
So what I would do is prepare a summons, a petition for modification, and a proposed child support worksheet. Sometimes a client does not know what the other parent is earning, so we just estimate, and we might kind of bump it up from what the income in the last order was. We also have to file, so those are the state requirements, the summons, petition, and the worksheet. Each county, and it varies by county, has other requirements for filings. So for example, in King County, and in most counties, you also have to file a financial declaration, and that's just a statement of income and what your monthly expenses and debts are. Most counties require submitting pay stubs, whether it's your most recent. King County is the most stringent. They want your last 6 months worth. You are generally also required to file your last 2 years tax returns and your last 2 years W-2s or 1099s. Or if you're self-employed, you'd file P&L or Schedule C, that kind of thing. Other proof of income, if you are not working, could be retirement statements or disability statements. And then most counties do not require the filing of bank statements. King County does. They want you to file 6 months worth. I may actually file bank statements even if it's not required, because I want to show the court, for example, that my client is living from paycheck to paycheck. And so those statements provide documentation that that's the case. And then for example, other supporting financial information that you also might want to file to corroborate that kind of thing are copies of credit card and loan statements to show that you're paying on these debts and they're substantial, medical, utility bills, that kind of thing.
Wow. It would seem to me that with the no retro rule and a lot of stuff that you need to file when you file, it might be a good idea for either the person getting the child support or paying the child support to have some sort of a folder accumulating this stuff. Inevitably something's going to happen, and it seems like even if you miss a couple, takes you a couple months sometimes to get some of this stuff.
Right, it does. Most people are fairly tech savvy, but some people don't have access to bank statements, for example, and they don't know how to get them. Yeah. They might be the kind of people that go to the bank to do their transactions and don't do online. So that's a consideration. Sometimes I may want more than just 6 months worth of bank statements. If we're asking for example, we can ask for a reimbursement for overpaid daycare or underpaid daycare. And so if a client is going back 2 years, then I'm going to want to have, their bank statements that show that they're making these payments. For example, if a parent was paying daycare of, their share, let's say, was $300 a month, and then we find out that the child had not been going to daycare for 2 years, then that person's entitled to reimbursement. And so they're going to have to do quite a bit of homework to get the documentation to show that. And then on that note also, if there's information that we need from the other party, once the case is filed, we can do what's called discovery. And that is to require the other side to answer questions and to produce documents, for example, to prove that a child was going to daycare and that they had been incurring those expenses and they had been paying them. So we may want to do that kind of thing.
Yeah. So that kind of leads to my next question. Once you file, what happens?
So once the case is filed, some counties provide what's called a case schedule, and that will just list the deadlines that you need to conform to regarding when a person is served and when you need to file certain things, when discovery needs to be completed. Most counties don't issue a case schedule. Again, King County is the most populous and organized, and so they do issue it because they need to keep their cases managed. So we arrange for the other side to be served, and the law allows the other side to be served by certified mail. I prefer to do personal service simply because the timeline for the other side's response is shorter. So personal service, they have 20 days from the time they're served to file a response to a petition, and then also their proposed child support worksheet and all of their other documents, financial declaration, that kind of thing. If a person is served by certified mail, we would do it to their last known address. And again, from the date of delivery, and that is tracked by USPS, they have 60 days to respond as opposed to the 20 days. So it's a longer time period during which they can gather all their materials and get them to us. Oh, and then another thing I wanted to point out is for petitioning parties who believe or who know or believe that either the child or either parent is receiving any public benefits. And that can include, in Washington, it's Apple Healthcare. A child can be covered by the state medical, or if they receive food stamps or any kind of monetary assistance. They are required to notify the county prosecuting attorney family support section. And then the state may appear in the case on behalf of the child, but more likely they will simply want to review the child support order as it's going to be submitted for signature by the court. So they want to see the final order and they want to be able to make any edits to it. And so that's something that I do just before we enter either an agreed order or before we go to trial.
Got it. Well, is there always a hearing on this? Is that built into the system?
Yes. For child support modifications, the state law is that you have what's called a trial by affidavit. And what that means is this is not a typical family law trial with testimony and exhibits and witnesses, that kind of thing. It is basically a trial based on the documentation that each side submits. Now, you do get a little bit of time for oral argument. Usually it's 5 minutes. It can be up to 15 minutes per side, where you can, tell the court your story, and the court has the option to ask you questions. If you do want to have witnesses and actually testify, you can file a motion for testimony and have the court decide whether that's allowed. And one instance where I would say that might be important is if you have a daycare provider who is a family member, because a lot of times there's a lot of fishiness going on there. So questions about, do they really get paid, that kind of thing. And so I might want to have a daycare provider testify that they actually were providing the daycare and they send invoices and they did provide the service.
How long does it take?
Child support modifications usually resolve within 3 to 4 months.
Okay, that's not bad.
Short track as opposed to divorces, and which is usually a year, and then can take much longer than that often.
And just again, I was going to say it, just make sure everyone understands. It's not when the judge finally signs the order that it goes from there. It would then go back to when you filed. Correct.
Yeah, and that would be stated in the order. It'd have a beginning date.
So you've been talking about, changes of income and all that kind of stuff. So the court has to figure out the income, and if it's enough to make a change. And what are some of the standards that they determine those things?
Okay. The court will consider almost all income, regardless of what it is. Salary, overtime bonuses, self-employment income, income from second jobs, dividends and interest, retirement income, disability income, spousal maintenance, if you receive that, has to go in the worksheet, Social Security income, nearly everything. The only types of income that are excluded from calculations are but need to be disclosed regardless of whether they're excluded, is income from a new spouse or domestic partner. That's really important if you're doing a modification, because that can have an impact on the court's decision. So if a person's newly remarried and that the new spouse has $8,000 a month income, the court will definitely consider that as house. It's not actually included in the child support worksheet in the calculation itself, but it has to be disclosed in the worksheet.
Got it.
And not only spouses, even just new domestic partners.
Right.
Other exclusions are child support that a parent might be receiving from another relationship. That's not included as income. Or again, any food stamps, monetary public benefits that a person receives. And then income from second jobs and overtime. Generally, that's required to be included in the calculation itself. However, if a party can prove that they have that second job or they have that overtime income just because they're trying to pay down debts, and then once the debt is paid, they will no longer have that income, then the court can exclude the income from a second job or overtime.
I got it. What if I don't have income because, I'm tired of paying, and I, go to my boss and say, cut my income in half, I'll work half time, or I don't want to work. And then I'm going to go in there and I ask them to, end child support. How does the court deal with that?
So what the court can do, or what the court shall do, if it finds that a parent is either underemployed or voluntarily underemployed or unemployed, is it will impute income to that parent. And there is a priority list of how the court imputes income. The first would be what the current rate of pay is at 40 hours a week. So if a parent is making $40 an hour, but they're choosing to work only 20 hours a week, I would advocate for my client on the other side to impute that parent at $40 an hour at 40 hours a week. We can also go off historical rate of pay if we don't know. I was saying when you file a petition initially, sometimes you don't know what that other parent is earning. So you can go off historical. And you could use the income in the current order of child support, but I like to bump it up a little, because we're presuming that a parent has gotten raises. And so we can go off historical rate of pay and increase it. If a party has not had much of a history of working, what I would do is probably impute that person at the state's minimum wage, which right now is very considerable. As of 2023, it's now $15.74 an hour in Washington. So those are some of it. And there's the last resort, if you really have no clue, let's say it's been 10 years since the current order was entered, you have absolutely no clue, you can go based on the federal median wage for a person of a certain age. That's the last resort, though.
So we're almost running out of time, but I do want to talk about one last thing, which is, you mentioned the standard calculator, which generally, you put in a bunch of figures, income, time with the kids, and it spits out, what it thinks it should be. But you also talked a little bit about some of the things that, might not be included when you're modifying, and they call it a deviation. And but there's some others, aren't there? I mean, can you have things other than income? What if I just inherited, a bunch of diamonds, but my income hasn't gone up? I mean, are things like that, can that be used?
Yes. So a court can consider either an upward or a downward deviation based on several factors, which again, you need to document and substantiate. The first one is very common, and that's the residential schedule of the child. So if a child is spending a good amount of time with the parent who's obligated to make the payment, then you could potentially deviate downward for that person's payment, because obviously they have increased expenses for a child living in their household, let's say 50% of the time, while the other parent may have decreased expenses. And you do need to sort of prove that that's the case. It's not an automatic thing. And that's especially if if the paying parent's income is much higher than the obligee parent, then I've seen courts not deviate downward because of the residential schedule. So, and then the other thing is it must not result in insufficient funds in the other parent's household. So again, if the other parent's only earning $3,000 a month and they're barely getting by, even if the other parent has the kids 50% of the time, you can't deviate downward if the obligate parent doesn't have money.
Yeah.
Another reason for deviating downward would be children from other relationships. So if a paying parent has kids in their household that they're supporting, or is paying child support for other children, not of the relationship, that parent could potentially deviate downward due to his obligations. Possession of wealth, you kind of mentioned that, diamonds. So again, the lottery scenario, if they on the lottery, you can deviate upward because of substantial wealth. Another reason to deviate downward would be debt and high expenses. And this needs to be debt that's not voluntarily incurred. And I mentioned, like a medical issue that, caused a lot of bills, not voluntarily incurred.
Yeah.
And then just one last point, generally parents cannot agree to deviate downward. They can agree to deviate upward. But if that's the sole reason that they agree, a court generally is not going to go for that. And I've had a lot of orders rejected because I've had parents who wanted to agree to nothing, or because they felt like they both could care for the children and didn't need it. And a court, that's against public policy. There needs to be a child support payment.
Yep, that makes sense. Best interest of the child. So we're going to have to go. But if you had one piece of advice, one word of wisdom to give someone in this kind of a situation, what would it be?
Document, document, document.
I love it.
Because this is you need to document your finances.
It's a you said it was a trial by affidavit. I mean,
yes.
You got to have the stuff there, to make it work. So thank you very much, Christy, for joining us today. This was really, really informative. And once again, you made it understandable, complex stuff, to folks like me, which is no easy task. So thank you so much for joining us today.
You're very welcome.
And everyone else, thank you for joining us today as well. Anyone with further questions on today's topic, you can post it here. We can absolutely get you connected with Christy. Till next time, stay safe, stay happy, and be well.